When people say that Tinubu can never be removed from office, that no judge will ever try that the Nigerian president has too much powers, this, that, they are actually saying it without looking at the facts that are different in Tinubu's case. Tinubu's case is so different that you can't compare it with Buhari versus Atiku in 2019 or Buhari versus Yar'Adua in 2007. Also, when people make these kind of statements, they forget that we have a judicial precedent on the sacking of a former president. So if a former president has been sacked by the court, why will Tinubu's case be different? Yes, NS Shonekon was sacked in 1993 by a federal high court, but people will say, it's not a fair comparison that NS Shonekon wasn't elected. But NS Shonekon actually collected pensions as a former president. He even attended Council of State meetings. So if he wasn't a former president, why did he enjoy all these largesses that former presidents enjoy? Also, the 1999 constitution we are using today was given to us by the military. And some of the decrees that military men made in the past were all consolidated. When the Fourth Republic started, they were all made acts of parliament. Now, let's see the similarities between Tinubu and Shonekon. Shonekon was appointed by former Nigerian dictator Ibrahim Babangida. Babangida was under serious pressure after he annulled the election of MKO Abiola, plus the $12 billion of oil revenue that Nigeria made during the Gulf War in 1991. He couldn't account for any of them, so under serious pressure, he had to quickly find a way to leave office. That made him to appoint NS Shonekon as an interim president. Now, on Tinubu's side, he was appointed by Buhari with the aid of Mahmoud Yakubu and others who participated in the heist that took place in February 25, 2023. Like Babangida, Buhari was also under serious pressure, having plunged Nigeria into serious debt. He couldn't solve security challenges despite spending billions of dollars in new equipment for the military. Even his home state of Katsina and neighboring state of Zamfara are still till today plagued by banditry and insecurity issues. That's why he couldn't stay in Nigeria after telling Nigerians that he performed wonderfully well, but he couldn't stay in Nigeria. Now, let's see what the court said when they sacked Shonekon. The court said that his position is unconstitutional, that Nigeria's constitution does not recognize an interim president. Now, let's see the constitutional matters that the court will look at in Tinubu's case. Tinubu is the first person to take oath of office as president of Nigeria without winning 25% in Abuja. Since the Fourth Republic started in 1999, no person has ever won the presidential election without winning his region. Obasanjo won the southern region in 1999 and in 2003. Yar'Adua won the northern region in 2007. Goodluck Jonathan won the southern region in 2011. Buhari won the northern region in 2015 and in 2019. All the past presidents all scored the mandatory 25% requirement in Abuja before being declared winner of the presidential election. Only Tinubu failed to meet this important requirement. Mind you that the constitution says that if there is no winner after the first round in a situation where there are more than two candidates contesting for the presidential election, in the second round, Abuja 25% is not required. So the drafters of the constitution know why they did it that way. And it is the law. So far that it has not been amended, it is the law. So the court will look at the constitutional requirements that Tinubu failed to meet. When they finish that, they will go on to the election proper, whether he scored the lawful votes, whether he met the 25% spread in 2/3 of 36 states of Nigeria. Because going by the Beavers report, tendered at the Presidential Election Petition Tribunal, it shows that he benefited from overvoting massively in many states that runs into thousands of votes. So the court will look at all this evidence and do the needful. Theirs is to answer the questions posed by the petitioners. The petitioners in their pleas are asking the court to do many things to see whether the constitutional provisions were fulfilled by Tinubu before being declared winner. So they will look at the plea and look at the evidence. If they are convinced, they will rule in favor of the petitioners. So looking back in 1993, from the glory days of the Nigerian judiciary, when there was so much pride in being a judge, when the society held judges in high esteem, when they made judgments against military governments and nothing happened, why will any judge fear Tinubu today? The work of a judge is to interpret the law, no matter who is involved. The law is no respecter of persons. They will just need to interpret the law and deliver judgment. And going by the precedent set in 1993 by a Nigerian judge, that means that precedent will be repeated. They will look at that precedent and say, yes, a former president was sacked by a court of law. It is possible to sack another in 2023. Provided that there are constitutional breaches, the judges must uphold the law. Besides, the judiciary arm of government needs to redeem themselves. Because if they allow people that didn't win an election to retain power, going by what happened during the election, these people will never obey court orders. They will ridicule the judiciary arm. When you make orders as a judge and the executive arm does not obey it, what's your authority as a judge? Lawless people can never obey the law. They're already showing their lawlessness, keeping people in detention. Why do we always put the cart before the horse? It is the horse that drives the cart. You cannot keep someone in detention while you're conducting investigation. That's not how it works. These people do not have immunity. You can question them or even invite them over and continue your investigation. When you are through, you can now charge them to court. You don't even need to finish all the investigation. Once you get something, you get one charge alone, you can charge the person based on the charge. While he's facing that charge, you can continue your investigation and you can charge him after, even if the person has been convicted by the court. You can charge him on another charge that is different from the one that he has been charged. That is how to do it. No matter the gravity of the crime they committed, whether they stole billions in dollars or naira, it still doesn't negate the fact that they deserve fair hearing. Yes, that's the position of the law. This same thing happened to Dasuki. He was kept in detention by the Buhari administration for many years without being charged. This is the reason many people are flight risk. They can run away because security agents detain people indefinitely. If people are aware that whatever they did, once it's a bailable offense, he will never spend more than 24 hours with the police. People wouldn't have any reason to run. Like in developed countries, why are you running? So that is the situation. It is actually the behavior of security agents that makes people to run away from the law. If they know that, after all, I'll go to court, they'll give me bail, that's the end, I've answered their questions, why will you run? You just go back to your business and continue your affairs. These kind of intimidations are what the EU Observer team talked about in their report. Do you know that some state governors withheld salaries of workers just because they didn't win an election? They gave them some conditions that they must go and canvass for votes for them, and they withheld their salaries before the election. Some continued withholding the salaries after they lost the election. Can you imagine that? Can you imagine the level of abuse of power? Everyone should go and read that EU report. Now, let's answer some questions. Steve wants to know what documents they will rely on to recalculate the results in case the court orders a recollation of the results. It's still the same thing. They will follow the process for resolving disputes in collation. If a party is contesting a result at the collation level, there are laid down procedures on how to resolve the dispute. In this case, the IRF copy is mutilated. They will go down to the next one, which is the police copy. If the police copy is not available, they will go down to the political party agent copy. So if the court orders a recollation of the results, they will still follow the law and collate the results the way it's supposed to be collated. Camillus wants to know when the judges will start collating the results. Will they rely on the mathematics professor to show that P2B won? The process is already on as we speak, and all parties won't be present while they decide, because this is evidence we are talking about here. The court will never invite all parties when they are going through the evidence. It doesn't work that way. The only time all parties will be involved is during recollation, assuming that will be the judgment of the court. This matter is very easy to determine. The judges cannot give you what you didn't ask for. That's not how it works. Theirs is to look at your plea and go and check the evidence you tendered. If they are convinced by the evidence, they rule in your favor. If they are not, it becomes the opposite. That's why it's very important to tender convincing evidence in the first place, which in this case, the Labour Party and the PDP did a very good job. Thanks for watching.